Okay, people of the state of Michigan versus Joshua Robert Dudley, 2123826. Mr. Dudley is here appearing by video from the St. Joseph County Jail. Mr. Bush is his attorney and Mr. Gabriel is the prosecutor, and it's set for a plea today. Mr. Dudley, if you'd raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Gabriel, what's the offer?
Your Honor, there are 3 counts of resisting obstructing in the information. Mr. Dudley would enter a plea of guilty to count 1 and 2, 2 separate counts on 2 different officers. In return, we will dismiss count 3 as well as the habitual offender notice. Oh, he'll plead no contest.
Okay, good. And is that correct, Mr. Bush?
That is absolutely correct, Judge.
Mr. Dudley, the offer in the case is that you plead to 2 counts of assaulting, resisting, or obstructing a police officer. Those are felonies punishable by up to 2 years and/or a fine of up to $2,000. And a consecutive sentence may be imposed if the assault was committed in a place of confinement or for another violation arising from the same transaction. The 3rd count of assaulting, resisting, or obstructing a police officer would be dismissed, as would the habitual offender. Is that correct?
Yes, sir.
All right, now, Mr. Gabriel, these are discretionarily consecutive. What's your position on consecutive versus concurrent?
Given it was 1 incident, Your Honor, I have no objection to the court going with consecutive.
Consecutive?
Or concurrent, I'm sorry. Concurrent.
Thank you.
You'd have no objection to doing consecutive. So, Mr. Dudley, what he's indicating is that by law, a person that commits an assault, resisting or obstructing, if they have another charge of that, they could run consecutive to each other, which means you would finish 1 sentence before you start the next sentence. He's indicating in this case that he has no objection to it being concurrent, which means that they would run at the same time. You understand that?
Yes, sir.
You understand they could have run consecutive to each other.
Yes, sir.
You also understand that since you're on parole, these cases are mandatorily consecutive to your parole case.
Yes, sir.
Now, I'm told that you wish to plead no contest due to a lack of memory due to intoxication. Do you understand that a no contest plea is the same as if you pled guilty? The difference between the two is that in a guilty plea, you would tell me what happened that makes you guilty of the offense. In a no contest plea, I would get it from some source other than you. So I would get it from the police report or some other transcript or something like that. But I would have to be satisfied that there's a factual basis to establish that you committed the offense from that other source. If I were able to be satisfied with that, then the conviction enters the same, your sentence just the same as if you pled guilty. You understand that?
Yes, sir.
So there's no asterisk that says, oh, but he pled no contest, so he really didn't do it. If I don't believe you did it from my reading of the report, then I won't accept a plea. So you're indicating that you don't have a memory to tell me what happened, but you don't dispute what's in the police report, and you can go with that. You understand?
Yes, sir.
Okay. So how do you plead to count 1? Charge of assaulting, resisting, or obstructing a police officer, a felony, punishable by up to 2 years in the Department of Corrections and/or a fine of up to $2,000.
No contest. Yep.
And how do you plead to count 2, the same charge?
No contest.
Now, has anyone promised you anything other than what we've talked about in court today?
No, sir.
Anybody threaten you?
No.
Are you doing this of your own free will?
Yes, sir.
Do you understand that once your plea is accepted, you'll not have a trial of any kind, and that you'll be giving up the right to a trial and all the rights that you would have had at trial? Do you understand that?
Yes, sir.
You understand that that means you're giving up the right to have a trial of any kind. You're going to give up the right to be tried by a jury, to have to be presumed innocent until proved guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question the witnesses that appear against you, to have the court order any witnesses you have for the defense to appear at trial, to to remain silent during the trial or to not have that silence used against you, and to testify at trial if you want to testify.
Yes, sir.
You also understand that if your plea is accepted, you may be giving up the right to appeal certain issues that would otherwise be appealable if you were convicted at trial. Further, any appeal for your conviction and sentence pursuant to the plea will be by application for leave and not by right. You understand that?
Yes, sir.
Okay. So I've been given a copy of the Three Rivers Police report related to this, and it will be admitted as an exhibit for both the plea and sentencing, and I'll review it. All right, first off, let's go back a little bit. Mr. Bush, you indicated that the reason that he could not enter a guilty plea is that due to intoxication, use of controlled substances, he didn't have a good memory of the evening. Is that correct?
He had shared with me that he believed he got bad stuff. I don't know if there's any good stuff in drugs, and it was creating memory and hallucination problems with him. That's what he told me when I first met him.
Okay. So yes, and Mr. Gabriel, you have no objection to no contest plea due to lack of memory.
I do not, Your Honor.
Right. First off, just for Mr. Dudley and anybody else watching, voluntary intoxication of a controlled substance or liquor is not a defense to a criminal charge. So whether he was high or not does not matter. It's the risk you take when you take controlled substances that you will be held criminally responsible for your behavior. Two, I'll read from the police report, which indicates that the Three Rivers officers were called on May 1st, 2021 at 6:11 in the evening to 701 8th Street in Three Rivers, County of St. Joseph, State of Michigan. Officers were called regarding an assault in progress. 3 police officers from the city of Three Rivers arrived. Officers were called to 701 8th Street for an active assault. Upon arrival, it was observed by officers that the defendant was assaulting a N. Morgan who had fallen between some residential debris in a garage door and could not defend himself. Officers first issued verbal commands. When that was unsuccessful, they went hands-on. Officers ordered Dudley to roll to his stomach. Dudley began kicking and grabbing onto the officers. At this time, Officer Dibble deployed his first taser cartridge. The first taser deployment was ineffective, and after a moment, another cartridge from Officer Dibble's taser was deployed. This cartridge was also ineffective. Dudley pulled the taser wires away and continued to resist. During the struggle and throughout the incident, Dudley was continuously stating, quote, "God has forgiven me. They've killed me. Don't let me die in this car or bed or chair." At this time, officers were able to get Dudley into cuffs and began guiding him to a patrol car. Dudley continued to resist and grab onto officers while being taken to the patrol car. While attempting to place Dudley into the patrol car, Officer Hewitt was kicked in the face, but sustained no injuries from this strike. Dudley was eventually secured in the vehicle. At this time, H. Morgan and N. Morgan advised that Dudley had ran to the residence and began assaulting N. Morgan unprovoked. Morgan stated he didn't want to press charges as Dudley was on parole and he had enough going on. Officers then transported Dudley to Three Rivers Health for medical clearance, as it was suspected that Dudley was under the influence of methamphetamine. He was grinding his teeth, had white rings around his mouth, involuntary jerking of muscles. While at the hospital, Dudley continued to resist, kicking and attempting to break free of the officer's grasp. He was then taken to the jail, where he continued to resist jailers and had to be restrained. He is a parole absconder who cut his tether off the day before. This was handled by Officer Dibble, who advised that Dudley was evading arrest. The officers notified his agent of the arrest. Our counsel is satisfied that the statements contained in the police report establish a factual basis for at least two counts of assaulting, resisting, or obstructing a police officer.
Prosecution is, Your Honor.
Defense is satisfied, Judge.
Are either counsel aware of any other promises, threats, or inducements?
I am not.
I'm aware of none.
Has the court complied with the court rule?
I believe the court has.
The court has complied.
I find the plea made is accurate, understanding, voluntary. There's a factual basis, therefore I accept the plea. Set this for sentencing on July 16th. Bond is canceled, and we will see you back here on July 16th. Mr. Dudley, you need to fill out that packet and get that turned in immediately to the jailer so that they can forward it to the Department of Corrections. It needs to be filled out completely so that we can do an accurate pre-sentence report and be ready for sentencing on July the 16th. That concludes our hearing for the day. Thank you very much.
I assume that's at 1 o'clock on the 16th, Your Honor?
Yes.